Any mention?
Well, in item number 27, my lord, I was supposed to place the record, my lord. So I need some more time to obtain the record, my lord.
1 second. Item
27, my lord. Come after 2 weeks, my lord.
No objection.
no objection. On Jan B. Marak.
Yes, my lord. This is not my matter.
No objection.
No objection.
Yes.
Please, Your Lordship. Lordship, I beg to mention item number 25, Lordship.
$35.
25.
25.
Yes, Lordship. 25.
Who is for the petitioner? Mr. Day.
My lord.
Why?
Our current counsel is not ready with the matter, Lord.
Who's on the council?
Mr. Ensinkon.
After, it's urgent. Any urgency?
There was urgency because the lady, she is claiming the pension of her father.
1 week,
my lord.
yes.
1 week.
About 1 week.
Madam, I have it after 2 weeks.
It'll become 2 weeks only because next week is.
Yes, then it's okay, my lord. 2 weeks.
Yes. 2 weeks,
My Lord.
not 1 week.
Please, Your Lordship.
Yes.
Your Lordship, I beg to make a mention for unlisted motion, Your Lordship, for today.
Regarding?
This is actually, Your Lordship, the respondent KHDC has construed with a court order, Your Lordship.
Has?
And construed with the court order and has issued an impugned letter directing the Sardar to convene a Darbar for election of headman, Your Lordship, which will be held on 31st March, that is on Tuesday, Your Lordship.
Is in violation of the orders of the
Yes,
court?
yes, Your Lordship.
But it has already been filed.
Yes, Your Lord, in the process of filing, Your Lordship.
Yes.
May I please, Lordship, I beg to mention item number 29, 30, 31, 32, 33, and 34, Lordship.
No wholesale adjournment.
Yes. All are connected matter, Lordship.
All connected matters.
Yes, Lordship.
From 29. From
7,
29.
29 to 34, Lordship.
Why?
Contempt counsel is having some personal difficulties.
What's the matter about?
PDS matter, Lordship.
This is stay order also, my lord.
Yes?
This is stay order operating also, my lord.
The order, that means more urgency to
Yes,
hear
my
this
lord.
matter.
After 2 weeks,
After
Lordship.
1 week. After 2 weeks, yes. 29 to 34. Yes.
Much obliged, Lordship.
Interim order. This is until further orders.
May I please, Your Lordship?
Yes, interim orders until further orders until next date. Where's it? Mr. Mara. Is until further orders or till the next date, interim order?
Continue, Lordship.
It's continuing. Okay. Yes.
Much obliged.
May I please, Your Lordship? I beg to mention item number 23. For 2 weeks, my lordship.
Why? What's the matter about?
Regarding the lane.
What's the matter about, Mr. Khai?
Lordship, I apologize.
Doesn't
Lordship,
matter.
it's Miss Zedi Nokri and such lies matter. They are not here.
What's
It was sent
doesn't
for
matter?
it was sent for mediation, Lordship.
23.
23.
23.
What's the matter about?
It's regarding the.
The matter was sent for mediation.
Yes, for the mediation, my lordship.
Okay, yes. I 23 last order. Yes. What's your name?
SW Sangma, my lordship. SW Sangma.
Yes, Mr. Separate start. As the mediation was not successful, matter B is for hearing after 2 weeks.
Yes, my
Clear
lordship.
all this.
All right, lordship.
You look at the order sheet if you mention, so you know why. Yes.
Please, Your Lordship. Your Lordship, I beg to mention item 35. No objection, Your Lordship.
No objection. How long?
2 weeks, Your Lordship.
Standard 2 weeks. Yes.
Thank you. Highly obliged.
We're mentioning again.
Lordship, item number 20, Lordship, joint case.
Then we'll rise now. Item number
28, Lordship. 28.
what's the matter about?
This matter is regarding non-allocation of SC to an SC candidate in MCS results declared now.
No objection?
No objection. This can be taken. Much
Lordship.
Supplementary list item number 1.
Yes, the what is it?
May I please, Lordship. Lordship, respondent number 2 has invited a tender for the appointment of hard representative, Your Lordship. Thereafter, I paid all the requisite fees.
Where's the invitation?
Annexure number 1, Lordship, page 13.
What's hard representative, Mr. D?
Hard representative, my lord, they will take care of the heart, my lord, where district council collect tax for entering of the goods into the market. But this heart representative, my lord, they are the one who will operate the heart, my lord, or take care. It's a heart committee type of thing, my lord. But this is not. This has been issued by the Cotton Grower Association. Is an association within the district council, my lord.
They have the authority.
They have
notice.
They have, my lord. It is as per the regulation.
Lordship, as a result, I was the first successful bidder, Lordship. Thereafter, the offer amount I wanted to pay to the office of the respondent number 3.
Where do you
offer
how
amount?
do you know that you're a successful bidder?
Successful bidder.
My lord, can you come to page 20?
20, Lordship.
Yes.
He's not successful. He's the highest bidder, my lord.
Lordship, it is the successful first bidder.
Where's the name?
1, 2, 3, 8 column, Lordship. Damal Asim.
Yes. Yes.
Your Lordship, to pay the offer amount, I visited the office of respondent number 3 in many occasions, Lordship, but I was not allowed to pay the offer amount. Thereafter, Lordship, I have even.
But this was done since last year.
Yes, Lordship.
Then,
Lordship, I have come to know. I have learned. Come to know that now it was settled with respondent number 4, Lordship. So I have come today, Lordship.
No.
It's commencing from 1st April. I have come to learn the appointment of hard representative was settled with the respondent number 4, Lordship.
this is annexure 10.
Lordship, there is no paper with me. The office has not provided me with the paper.
There is nothing to show in this petition, my lord, that he has approached the district council.
Lordship, I have mentioned in my paragraph number.
Where's your letter offering the payment?
There is on page 21, my lord. Now, who has received this also, my lord, we don't know. There is no seal, no nothing, my lord.
I have addressed to the respondent number 3, Lordship, this letter.
21?
Yes.
Connection
Type copy is 21A.
You get instructions.
I will take the instruction because it is a different organization, my lord.
Read Mr. L. Coach, Council Appreciation Notice. Mr. S.D. is present on behalf of respondents 1 and 2. An accept notice, no further notice of respondents. Notice issued to respondent number 4 within 1 week. So, the grievance with petitioner is that he is in spite of being the highest bidder for settlement as hard representative. Which market?
Damal Asim, Lordship.
For Damal, where's that?
Asim.
For Damal Asim, DAMAL, ASIM market. This is situated where?
This is in Damal Asim, Lordship. West Garo Hills. West Garo Hills.
West Garo Hills.
Lordship.
West Garo Hills. The respondent number 3 has refused to accept the bid amount, and he has and the learned counsel submits that he has come to learn that the same has been settled with respondent number 4. However, as he does not have any tangible proof before this court today, SAD is directed to obtain instructions. Just after, we need to get fixed the list on 7th. 7th, right? 7th, yes. April.
I'll have it.
Item number 2.
May I please, Your Lordship?
May I please, Your Lordship, before the senior
Where Dr. Muska?
he's currently out of station, Lordship. I'm praying if Your Lordship would have this matter on the 7th.
Is there any urgency?
There is no urgency as such, Your Lordship, because the contract has already been awarded to the
When was it awarded?
30th of July 2025.
Or 25? Then there's no
Yes.
urgency.
Yes, that's
because
why I
the DSCI is not in town.
Okay.
So what do you propose to do? You take a date.
Sure, I will take a date. In the meantime, Your Lordship, few documents of my pleadings were also inadvertently left out. Allow me to...
We'll record your name?
A. N. Das, with Ms. Priyanka and Mr. Andy.
I heard Mr. Ian the counsel petitioner. If you notice, Mr. Vice Dr. Ambrose Callan, JCI, will accept notice on behalf of
Respondent 1, 3 and 4. 1, 3 and 4.
1, 3 and 4. Notice to issue to the remaining respondents by next week's stop. What is you're seeing some defects?
Procedural irregularity is there. Some documents were left out, Your Lordship, inadvertently. I had stated that the entire pleading is there, only writ is there, counter and rejoinder of the earlier writ petition is not there. So those two.
Ms. Ian submits that due to inadvertence, certain other documents such as the rejoinder
and reply by the respondents.
Reply by the respondents filed in the earlier writ petition being WC number.
Annexure number
25.
15.
Annexure 15. WPC number.
85 of 25.
Page number?
85 of 25.
WPC 85 of 2025.
I've been left out. Inadvertently, so I've been left out. So the place was permitted to bring the same report by way of affidavit before the next date. You also list after when on. Yes.
Sir, any date convened to the Honorable Court and Mr.
Yes.
Daily list item number 1.
What's the date, Lordship?
The court master will give the daily.
Please. Much obliged.
Please, Lordship. Lordship, this matter may be adjourned for a date, Lordship. Since the conduct counts, maybe adjourned for a date, Lordship.
For a day?
Yes, Lordship. Lordship, since the conduct counsel, Mr. A.S. Pandey is not available, Lordship.
You're here.
Lordship, but in Lordship, he is the conduct counsel and
every adjournment taken on your behalf by MSS Lalu, that Ms. Karonlang is not here.
Well, last week I was not.
Then you'll take adjournments on behalf of Pandey. Pandey take adjournment on behalf. How will this continue like this?
My lord. My lord.
Yes, Mr. Karkan.
Yeah, but next week, Lord should be informed us yesterday.
We have already informed Mr. Job.
After 1 week, yes.
Obliged.
Item number 2.
Please, Lordship. Here I'm praying for if it can be taken up next week, my lord. The petitioner is unwell. She could not come and.
There's nothing to.
We tried to, Lordship. We have communicated to her.
You have to take whether you want to
pursue it or not, Lordship. Yes. So we have called the petitioner to come and just explain the documents and.
Explain documents. Judgment division bench is there.
Lordship, yes, because
the agent can't be considered. So
I'm just praying if it could be taken up on 2nd or 3rd, my lord. She could not come because of her ill health.
Personally present when the matter is taken up.
No, not for to enable us to show, Lordship, that what is the mind of the court.
This matter has already been.
Also, we have communicated the order also. So I'm just praying for a week's time to just finish.
Third or fourth adjournment. Only on
2nd, because she is not well, my lord. She is not able to come and just
You know what the outcome is going to be, Mr. Dev.
Lordship, we have communicated to her in. She says that she wants to just come and, my lord, it would be better if she comes and just has a physical discussion. That is my only prayer. I'm just praying for 1 week. She could not come because of the ill health, my lord, since last 2 weeks.
Okay, Mr. Is that please the matter be adjourned?
For a week's time, Lordship.
Yes, after 2 weeks, yes.
Lordship.
Get well soon and then.
Lordship, she could not come. That's my only. I'm obliged.
3.
Please, Your Lordship. Your Lordship, we've already served the affidavit in advance to
Where's
the
the list?
respondent.
They have not given any list in that affidavit. They are saying it is still appointment is under consideration of a department. How can they consider
Your
now?
Lordship, may
Once
please,
the
Your
matter is
Lordship.
pending and section 11 is pending. At this stage now they want us to waive sign an agreement to waive, and then the serving officer they will appoint, and they want us to
When the affidavit, is it on board?
affidavit they have
We'll be
filed.
filing in the course of the day, Your Lordship.
Okay, let her file. MSc Jalal and it counsel for the respondents. Vice Dr. N. Modika submit that the affidavit and behalf of the will file in the course of the day.
But in their affidavit they have not suggested any
We
names.
can't help it. It's not before us. How
Yes.
can we see it now? Just after 2 weeks.
After 1 week, my lord?
2 weeks for rejoinder. Next week, nothing's going to happen.
Okay.
After Bihu then for you.
4.
I will write.
Yes.
For division bench, my lord.
Doesn't
Contempt
matter,
matters. And it is listed on 20th April, my lord. 20th April.
That's correct.
Yes, Your Lordship.
Yes, there is applicant submits that the matter before the division bench is still pending consideration. Connected matter to the division bench. Only just after 3 weeks, yes.
Right.
Please, Lordship. This is the contempt petition, Your Lordship. On the last occasion, the respondent number 2 and 3, they, despite of receiving the notice, they have not received. The order of the court is within the 6 months. Sufficient time has been given. Now it's more than 1 year, Your Lordship. The order expired in the month of October 2025.
No, where's the affidavit?
My lord,
They are supposed to file the affidavit on the last occasion.
I'm explaining. My lord, firstly, my apologies, my lord. The contempt, lordship, he is out of station. Yesterday he was traveling. We tried to get it to him, but then he could not find a notary, my lord. He is in Delhi at present, lordship. I'm
Who's
serving.
this
I'm
person?
serving a copy to the applicant here in lordship.
Who's the person?
He is a chief engineer, lordship. So I'm just praying he's coming back by.
The sub-divisional officers,
It will be your PhD
Bajing
or
Doba.
what?
Lordship.
What? He's PhD or PhD?
Yes, PhD.
What is the order?
Lordship, the
statement
matter
related?
may
Order,
come on the
Lordship,
first, my lord.
kindly see the page 13, my lord, because whatever state government was offering, we have agreed to accept, and it is their statement that we have agreed to take the money. We are not contesting. Actually, we claim that amount of our claim was more than 72 lakh, but they said that our due is only 25 lakh. So we said, okay, we will take it. It is their own statement, Lordship.
We will give him last chance then.
Lordship.
MSNG shall us pray that to be allowed last chance to find affidavit. Seems considered and allowed. Just up to 2 weeks.
Lordship.
Much obliged,
Let us file affidavit.
7.
Much plus, Lordship.
Yes.
Your Lordship.
You want to file a rejoinder?
Your Lordship, respondent 12 are yet to file their.
Lordship,
Will you file a rejoinder or not?
Your Lordship, after they've filed their counter, will file a club rejoinder.
But Mr. Snaitang made a very clever submission last time. He said I may be allowed to examine the matter whether to file a rejoinder or not. 4 to 8 and 9 to 11.
Your Lordship, we are waiting for respondents 12, Your Lordship.
12 is whom?
12 is I'm there, Your Lordship. That is assembly,
file or
Your
not?
Lordship. Will not file, Lordship, because
Yes. Okay, today Ms. Andy should I,
Week's time.
on behalf of respondent number
12.
Let AG12 submits the no affidavit report coming from said respondent. Sub MS BF Karwanlang to pray that she will have 2 weeks time to file rejoinder to the other affidavits filed by the respondent.
Your Lordship, if necessary.
Then we can't have that conditional.
Let the matter be
Lordship,
fixed
then
for
2
hearing, Your
weeks for
Lordship.
rejoinder.
2 weeks. Otherwise,
Oblige, Your Lordship.
Lordship, item 8 is connected.
7 days, Your Lordship.
9.
Your Lordship, I'm praying for 2 weeks' time, Your Lordship, to file the rejoinder.
How many times you prayed?
2 times with this, Your
This
Lordship.
third
Second
time.
time, Your Lordship.
2 weeks further time I prayed allowed for rejoinder. This is the last term also.
10.
Obliged, Lordship.
Your Lordship, I pray for 2 weeks' time to file my rejoinder.
This is your
Rejoinder.
Rejoinder, Your Lordship.
first time?
This is my second time, Your Lordship.
Yes, Mr. Lathangluya. Please from the allowed further.
2 weeks' time.
To send file affidavit, rejoinder.
Rejoined.
Obliged, Your Lordship.
11.
Yes.
In this matter, Lordship, the petitioner is supposed to take instructions on the communication because they've come for remonstration, Lordship. But
What instructions are they supposed to take?
Your Lordship.
Yes.
An objection was raised, my lord, regarding the joint petition filed by the petitioners, my lord.
Okay.
So, my lord, on the last occasion, letter was handed over to us, my lord. We were supposed to obtain instructions. My lord, I was to make submissions, but Dr. Musica told me he's not in town. So, my lord, let him be here, my lord. Then I'll make my submissions.
You make submissions to the court, you don't make submissions to the council.
No, my lord.
To the other council.
For him to reply also, my lord. For him to reply also.
Yes, Mr. No, nobody. Please, matter within after 2 weeks. Yes.
Deep.
12.
Yes, Your Lordship. In this matter, I'm praying for some more time to file an affidavit, Lordship.
The paper petitioner. You're for the petitioner?
I'm on behalf of the petitioner.
Yes. You grant them 2 weeks further time for affidavit? Yes. 2 weeks further time as prayed allowed for affidavit? Yes. Yes.
Obliged, Lordship.
13.
May it please your Lordship. Lordship, we are seeking further time, my lord. Filing the affidavit.
What's the matter about?
Is this a non-payment of the contract bills, Milan?
Yes, sir. MSNG Shilla prayed for allowed for the 2 weeks time to file affidavit. Yes.
13 and 14, my lord. 13 and 14.
15.
Obliged.
Much obliged, Lordship.
Please, Your Lordship. I'm praying for some more time to file an affidavit, Your Lordship.
Is against GHEDC?
No, my lord.
Oh,
Nehu.
sorry. Nehu.
Yes, Your Lordship.
You're with Mr. Sen?
Yes, Your Lordship.
Not with Mr. D, no? Okay. Yes, for the 2 weeks time as prayed allowed for affidavit.
16 and 17 also, my lord.
Connected matters.
Much obliged, Lordship.
18.
Please, Lordship. Lordship, we were required to file an additional affidavit to bring on record the advertisement. Lordship, because of the law and order problem in Garhwils, the petitioner could not come. He is right from that very constituency. I am praying for a week's time, Lordship, to file it.
What record? Advertisements on record?
Lordship, yes.
Yes,
3 advertisements.
Mr. S. Dev today submitted the affidavit allowed by this court by order dated 9/3/2026 not be filed due to the prevailing situation in Garhwils. The praise was allowed for the 2 weeks time. Yes, just after 2 weeks.
In the meantime, the state was to file affidavit and seek instructions, Lordship.
Lordship, as far as I have received verbal instructions for the same problem due to the prevailing situation.
let's have
But
2
firstly,
weeks.
my lord, the petitioner himself wanted to be a part of the special committee. Since he is not made a part of the committee, yes, we have it on record, my lord. So
19.
since he is not a part of the
Hamid, this is your Lordship.
Lord, service steps have been taken, my lord, for service upon the respondents. Which respondents?
7, 9 and 10.
Lordship,
One second.
What about 8? 7, 9 and 10.
7,
9 and 10.
9 and 10. So that leaves out.
Plus 8, I think, instructions by the end of the.
That leaves out.
1 to 6 is
number
8.
7, 9 and 10.
Leaves out number 8.
Rajesh Sana.
So I'll take instructions for 8 as well.
Very interesting name. He's got Rocket Sana. His name.
It's a rocket each.
Alias.
Rocket Sana. Yes, Mr. S. Sen has an appearance today on behalf of respondents 7, 9 and 10. He also prays him out to obtain instructions as to whether he will be representing the respondent number 8. So, yes, what is your report?
Lordship, I have the report with me, Lordship. Lordship, kindly.
Yes, what is more?
Lordship, from the report, it appears, Lordship, that money is the root cause.
It's always the root cause of all evil. Yes.
If Lordship kindly come to page 20, that is the summary by the subdivisional officer, Lordship.
20?
Lordship, yes. Before that, if Lordship kindly come to page 3, that is the finding of the inquiry officer.
Page?
Page 3, Your Lordship. Then I'll take a Lordship to the next.
Yes.
Lordship, kindly see with regard to the alleged disturbances.
You are done, Buam.
Yes, my lord.
Yes.
So, Lordship, kindly see, Your Lordship. Then, Lordship, kindly come to the bottom based on the statement.
Yes.
Based on the statement of all parties, and my finding, it may be stated for the benefit of all competent concerned parties, especially the tourist fraternity, the management and regulation of tourism activities at the Fair Fall may be temporarily undertaken by the District Tourism Promotion Society so as to ensure proper regulation, safety measures and facility of tourists until the matter is resolved. So, Lordship, I'm praying that in the interim, Your Lordship, because
Let us see.
Lordship. Then Lordship kindly have
one second, Mr.
Sorry, Your Lordship.
You've read the report. It's just you just put it here before us.
Lordship, yes.
So what's the scan proceed? This is running the voting.
No, the voting is not an activity. Voting is just to cross the river. So Scan Parishad is the Dorbar which have asked for commission from us, Malad.
That's what they're running, but they're running the activities now.
And the private dispute or the whatever dispute that is pending is between Scan Parishad and some other clan. We've got nothing to do with it. As far as running the Fair Falls by this District Tourism Promotion Society, we have no objections, Malad. That'll be good, in fact.
Yes.
Lordship kindly have page 20, Your Lordship. Then Lordship kindly have page 20.
What about pictures you annex here, people breaking stones?
Lordship, this is part of the inquiry, Lordship, what they have. Lordship kindly have page 20. Then then Lordship, I am taking Your Lordship to the relevant part at page 22, Your Lordship, action taken. This is the summary, Your Lordship, done by the subdivisional officer Amlaram, Your Lordship. It appears, Your Lordship, there is a civil dispute also before the
who are these Sumers now?
Lordship, Lord.
Who are they?
Treli Sumer is the owner on the other side, from the other side. So there's a dispute between Treli Sumer and this Scan Parishad Dorbar, my lord.
And you are on the Skantalang side?
We'll be on the other side, my lord. We've got nothing to do with that.
You're Skantalang side?
Yes, my lord. We enter from there.
Is with?
My lord, we have no dispute with anyone. The only thing is, while
only the Scan Parishad is stopping you
from crossing the river, and they're asking for commission, my lord. Whatever entry fee has to be paid is the landowner on the other side.
The landowner, your lord. Party also in this proceeding?
No, your lord.
No, my lord. No, my lord.
Okay. Then why is the name figuring here in the inquiry report?
Lordship, if lordship kindly have action taken, your lordship.
Yes.
In response, they stated that the forest land in question belonged to Shrimati Treli Sumer of.
Who stated that?
Scan Parishad.
Page 26.
She also running tourism business.
I don't know, my lord.
Then,
but it's her private.
She appear and say that Darbar Shillong is threatening them, vandalizing signboards is installed by them, also instruct them not to provide life jackets for tourists. So they also engage in tourism activity.
Well, they are on the other side. I have nothing to do with them, my lord. Whatever disputes they have, my lord, it's their own dispute, my lord. Whatever civil dispute.
Now, why then this inquiry has gone beyond the whatever
they are trying to entangle everything, my lord.
No, lordship. This is
claim decided a meeting to convene with both Darbar Shillong's convictions.
Lordship. Prior to that, lordship, this is the action taken by the SDO, your lordship. Lordship, kindly have page 20 first. Page 20. Kindly come back to page 20, your lordship.
Yes.
Lordship, kindly see dispute regarding tourism activities at Pepe Fall. A long-standing dispute has been reported involving Darbar Shillong Skentalang, Darbar Shillong Skenpersit, and Sri Don Bok Suyam, Buam regarding the management and conduct of tourism-related activities in and around the Pepe Fall. The SDO convened a meeting on 9/10/2025. This is lordship in the last year, with the concerned stakeholder regarding the dispute about tourism activities in the Crown, the Pepe Fall. During the meeting and subsequent inquiries, the following observations were made: no NOC and initial permission. The headman of Skenpersit village informed that no objection certificate was issued to Shrimati Bitil Tariang solely for the purpose of constructing homestay for accommodating tourism. However, tourist, your lordship. However, Shrimati so-and-so allowed Sri Donbok to operate the homestay in the said land. However, it was reported that the said individual extended their activities beyond the scope of the permission granted under the NOC by engaging the following activities: operating boat and ferrying tourists across the river, providing tourist guide service, collecting so-and-so, your lordship. Then, lordship, kindly have the statement of this petitioner, your lordship. That is below, your lordship. The tourist site has been functioning more smoothly and was generating income. However, he stated that some villages later demanded 50% of the revenue generated from the tourism-related activities.
This is the cause,
lordship. This is the main cause. Then, if lordship, I take a lordship to page 26. That is the statement of the headman of Skenpersit. Page 26, your lordship.
Yes.
He said, lordship, I'm not going there. Then, lordship, only a third paragraph, your lordship. Then the Darbar Shillong Skenpersit, lordship, has gotten informed the officer in charge, Amlaram police station, that Sri Donbok is still operating his tourist activities by allowing tourists to cross the river, though the bridge which is
right from the beginning.
Lordship, yes. My name is so-and-so, headman so-and-so, and the Amlaram subdivision. As the headman, I gave NOC to Bitil Tariang, owner of the land near Thlu Muwi, to lease it to Donbok Puyam to open a restaurant, homestay, guest house, etc. in the year 2019. Later, when he started his boating activities in Thlu Muwi, the members of the Darbar Shillong of Skenpersit approached Sri Donbok and asked him to stop his boating activities because the NOC was given only for homestay and restaurant. After this, he sent police force to Thlu. The officer in charge, Amlaram police station, visited the site and stopped Donbok Puyam from running his boating activities till the matter is resolved. Later, subdivisional officer summoned us as a Darbar Shillong and ordered the closure of boating activities at Thlu. Even after the closure notice from the office of the sub-divisional officer, Sri Donbok Buam, to still operate and run his boating activities by charging 100 rupees per person, and constructed a bamboo bridge which connected his homestay to Skentalang area. Then the Darbar Shillong informed the officer in charge, Amlaram police station, that Sri Donbok Buam is still operating his tourist activities by allowing tourists to cross the river through the bridge which is made out of bamboos. By crossing through the bridge, the tourists will reach Sken Talang village. No NOC was given by the Dorbasinong Sken Persit to construct a temporary bridge across the Tlumui, as the tourists will have to pass through private land to reach the Fefe Fall. The owners of this land complained to the Dorbasinong of Sken Persit that the tourists litter the place. That is why we have to stop him from operating in that area. We never demanded 50% share from his business. What we want is the tourists to pass through Sken Persit area to visit the Fefe Fall and other tourist spots, and to be guided by the local villagers from Sken Persit. Later, we cancelled the NOC given to Shimati Bitil Tariang by issuing a letter dated so-and-so, as Sri Donbok Buam failed to abide by the condition given in the NOC, that is by selling liquor in his homestay, which is illegal. After cancelling the NOC, we came to know that on 26/2/2026, one person by the name of late so-and-so died at Donbok Buam homestay near Tlumui, in which Donbok himself took the body to HSC Jarain without informing the Dorbasinong Sken Persit.
Okay, that's not important. So that is the core of the core.
Then, Lordship, kindly have page 31, Your Lordship.
The core. Only another says that, yes.
Kindly have page 31, Your Lordship. If I may read, Your Lordship.
The core issue, my lord, again, kindly have page 26, the third paragraph from the bottom. We never demanded 50% share of his business. What we want is the tourists to pass through Sken Persit area to visit the Fefe Falls and other tourist spots, and to be guided by the local. So basically, they want all the tourists to only come from the other
Lordship,
side.
kindly have page 31, Your Lordship. This is the statement of the headman of Sken Talang. My name is so-and-so, and the Amlaram Civil Subdivision. From the Dorbasinong, we have not given any NOC to anyone to run any tourists in the area falling under Sken Talang village, including Tlumui River, which act as a border between Sken Persit and Sken Talang village. As the Dorbasinong is still working on the rules and regulation for the safety of the tourists visiting the Tlumui River, due to this reason, the Dorbasinong stopped Donbok Buam from allowing tourists to cross the river and pass through our village to reach Sanrang Mui, the Fefe Fall, as we have received complaint from the landowners that the tourists pass through their land and dirty the place by throwing bottle, plastic, etc. Also, our women and children are walking in and around the area, thus creating fear among them for seeing group of tourists passing through that area. At the same time, the subdivisional officer Amnarem has passed an order to shut down Fefe Fall for the safety of the tourists. Meanwhile, Donbok Buam construct a bamboo bridge in Tlumui River connecting Sken Persit village and Sken Talang village, despite of the subdivisional order.
Yes, okay.
Lordship. Then, Lordship, kindly come to the bottom, Your Lordship. Later, the subdivisional officer, Amlarem, requested that both Dorbasinong, Sken Talang, and to meet and resolve the matter, but Sri Donbok Buam never appeared for any meeting or discussion to resolve the matter. So, Your Lordship, appear, Your Lordship, that
this is the kind of boat that you use. It's just a raft. In this page 29.
Page 29 of my petition, my lord?
Of the report.
No, report, Your Lordship, yes.
My copy is a black and white note. I can't.
No, this is sort of raw.
This is the original, Your Lordship.
Made out of plastic. What? Jerry cans. Let's come back to the SDO. What he has said.
Lordship, that at page 20, Your Lordship. If Lordship kindly have page 23, that is the recommendation, Your Lordship. Yes. Recommendation at clause 4, Your Lordship. The core issue in the present matter primarily concerns access and management of tourism activities at Fefe Fall. Despite several meetings and effort made by the administration to resolve the dispute among the concerned parties, the matter remains unresolved. In view of the continuing dispute between village Dorba and private landowners.
How do you resolve this now?
Lordship,
it will be a continuing kind of situation.
Lordship,
what happened? Krangsuri also came to this court. Who was appearing that?
Mr. Shalla was appearing.
Mr. Shalla.
That's been resolved.
I have no idea, Lordship. Lordship, it appears, Your Lordship, there is a dispute between the contesting parties, Your Lordship.
Not that, Mr. Shah. This is a trend is emerging now. In Chera area also, how many?
Lordship, yes.
Same thing. We see people
as I have submitted earlier, Your Lordship.
They want their hands in the pie also. That's what.
Money is the root cause,
the issue is,
money
when a complaint is made to the administration, my lord, they'll have to, my lord, adjudicate, my lord.
But there has to be another, there has to be another, what do you call it, system in place with regard to this, at least, with regard to permissions and so on and so forth.
Lordship, like
There
in
has to be
Sora,
tourism department
West
involvement.
Saudong, Daintland,
Everywhere.
all this, Your Lordship.
Everywhere.
After the influence of tourists, Your Lordship, then this dispute started, Your Lordship.
As it has been stated, my lord, in page 3, and it has been suggested, my lord, that the district tourism promotion.
Lordship, only my prayer, Lordship, that
Please supply with a copy of this report. I've not seen this report. And there is
in the meanwhile, Your Lordship will take over the management of this
Who's
spot.
in charge of the district tourism promotion society?
Lordship, just
where is it? It's here.
Lordship, his statement is there, Your Lordship. Just a minute, Your Lordship. If Lordship kindly have a page 25.
Lord, respondent number 4 is the district tourism officer, my lord.
No, where's constituted by whom?
Lordship, page 25. He also has been examined on the own. Page
So he's
25.
OC.
Oh, sorry, Your Lordship. I am so. Lordship, page 24. I'm sorry, Your Lordship. Page 24, Your Lordship. He's a tourist officer.
Tourism officer. Tourism officers, one one, my lord, SD Shilla.
No, tourism officers is Ranal Walang.
Well, in the meeting of 9th October 2025,
District Tourist Officer, respondent number 4.
one Srimati SD Shilla, District Tourism Officer,
Okay.
was appeared in the meeting, my lord. I mean, was present.
Well, Eviction was the chairman. Fine. Yes. It's fine, yes. What does he mean by petitioner Sri Dambak Boam appears in pursuing his agenda by filtering tourists? Filtering tourists means what? En route to Fifi Falls. Anyway, you take down a status report dated 18. A preliminary inquiry report dated 18/3/2026 has been placed before the court today. Mr. N.D. Shulai, Leonard EAG, has taken this court through the findings contained therein. So, from the inquiry, it appears that there are disputes between Scan Prashid and the writ petitioner. And the writ petitioner, with regard to the NOC that was granted, in as much as the respondent number, Scan Prashid respondent number,
Scan Prashid is
respondent 7.
7.
Bracket Darvashon Scan Prashid have maintained that the NOC was only for a homestay and not for conducting boating activities. So, further, it is also noted that Skantalang, which respondent?
Respondent number 10.
Number 10, my lord.
You're paying for them.
My lord, I don't think both the villages can be represented by.
No, they can't. You're paying 10 also.
Yes, please.
It cannot be, my lord.
Those are my
A
instructions.
totally different village.
Then it'll resolve the matter faster.
Yes.
Only you'll be squeezed in the middle.
They have come together. The petitioner cannot have any objection with that.
Yes. What? No? Karpashnongs can proceed. Stop. Another area of dispute is with the respondent number 10, Karpashnongs Kantalang, who have closed the falls. Correct.
Lord, they have erected signboards, not allowing anybody to pass through the
Who
village.
have restricted access to the tourist site. It appears from the report that there are also other pending civil disputes. The recommendation contained therein, however, is that the recommendation that's contained in the report, however, has suggested that for the benefit of all concerned parties, especially the tourist fraternity, the management and regulation of tourism activities at PV Falls may be temporarily undertaken by the District Tourism Promotion Society, bracket DTPS. It's also noted that the District Tourism Officer, where's that?
Lordship,
Page 24.
Page 24, Your Lordship, yes.
The Tourist Officer.
Tourist Officer, Your Lordship, yes.
West Chante Hills had also appeared in the inquiry and has explained and has appeared and also made a recommendation therein that the operation be taken over and managed by the Tourism Department and the District Promotion Society, which is under the chairmanship of the Deputy Commissioner West Chante Hills. Next one, the Learned Counsel for the parties. You have no objection also, Mr.
As far as I'm concerned, my lord.
No, but it'll be taken over the deed by the district.
As far as I'm concerned, my lord, I have no objections. But I do not know whether Radbuam, who's on one side from Skantalang side, and that Treli Sumer from the other side, who are the owners of the land, whether they'll have any objection. So your lordships may pass interim orders. I can implead them as parties. Your lordships may direct me to implead them as parties.
No, well, let the District Tourism Promotion Society take over first.
Yes.
No? Promotion Society stuff. The counsel for the petitioner is also not averse to the idea. Accordingly, in the interim, so that the tourism activities may not be disrupted, it is directed that the District Tourism Promotion Society, West Chante Hills, under the chairmanship of the Deputy Commissioner, is directed to take over and manage the operations at the tourist site. And as is the they have a standard operating procedure.
I believe so, Your Lordship.
The standard operating procedure prevailing with regard to collection and entry fees, the same shall be adhered to. Yes.
Lordship, payment of wages also to the.
So they have the SOP. They collect and they pay. Yes.
Lordship.
Yes. Stop. It is ordered accordingly. Stop. Next. Yes.
We'll file a reply. There are some
Yes,
serious questions with regard to the maintainability as well.
Mr. Philonovi also praised the allowed to implead for the necessary parties if the need so arises. The prayers allowed. Stop. Ms. Elson, please be allowed 2 weeks time to file affidavit.
That's also in the meantime a copy of that report will be supplied.
Lordship will.
We will record.
We will furnish that copy.
Yes,
Lordship.
Lord, report is taken on record, my lord. Report is taken on record.
But this is the recurring thing now everywhere.
Yes.
Especially in some areas in near Chera. And whenever someone puts up a homestay.
This happens mostly in Sora, Your Lordship.
The Popla, Your Lordship. What's happened to the matter in the High Court?
It's not listed as yet. That was the last order that was passed.
Then
in
what
fact,
to do?
the other matters that are even very new, recent matters have been listed before the Honorable Supreme Court with regard to the Allahabad cases. But as far as Shillong, well, that's the last order that has been passed, staying the eviction.
Only eviction has been stayed, but the other process has to still go on.
Proceeding, my lords, may I just explain this? The Honorable Division Bench directed for a redetermination and for a fresh hearing in this matter. We participated in the hearing. So now there are two offshoots of this, two parallel proceedings. The Goenka family decided to prosecute the matter before the Honorable Supreme Court. Now, they did not, to the best of my knowledge, they did not participate. Yes, my lord, that's what I'm told. They did not participate in the hearing before the DO.
Where's Mr. Paul?
In fact, in the Supreme Court, there's challenged the division bench order also, by which, but there's nothing has been said about that. I have
So
a
in
copy
case
of
that order of the division bench is set aside, my lords, that will have a bearing on me. So there are various different possibilities. If the Allahabad judgment is upheld, then all these demand notices are consequentially invalid. If that is set aside entirely,
Then I come back to my original proceeding where I'm challenging the order passed by the DO on a fresh determination. If the Goenka family succeeds in their SLP before the Honorable Supreme Court, then the order of the division bench is set aside. Now we have to see to what extent it will be set aside. So it's a slightly complex situation, my lord. I would submit I may be given the benefit of the same order. We will await for some time, my lords. I'm sure this will be taken up within the next few months.
So in the meantime, the STP, the proceeding, whatever we do.
No, my proceeding is concluded. That's what I'm trying to say. My proceeding is concluded. The Goenka family did not participate.
Order meanwhile subject proceedings shall go on.
The proceedings which were directed by the Honorable Division Bench for hearing of the matter.
That has been concluded.
I participated. It's concluded as against me.
What is the status of that proceeding?
Status, we have asked the demand, they are to deposit 40%. That was modified. 40% remaining, they are to deposit within 90 days.
What was directed by the Honorable Division Bench
don't want to lose the revenue.
Was for a fresh consideration of the rent. Now that was heard. A very cryptic order was passed. In any case, they upheld whatever STP was there. So that is where the proceeding culminated as against me. As far as the Goenka family, they have challenged the entire order. So they did not participate, to the best of my knowledge, in those proceedings. So it's a slightly complex situation. So there might be various different outcomes in those connected matters before the Honorable Supreme Court.
You are making a demand that they deposit.
Yes.
No, that is again our choice, my lord. So then they have the liberty to initiate proceedings under the PP Act and throw us out. So
we can't throw you out now.
Correct. That's what I'm saying.
By the Supreme Court.
Yes, but I'm asking for the same parity. That's all.
What parity? You already got the parity.
No, my lords. I'm saying that the order of the Honorable Division Bench was the similar order for everybody. The Goenka family questioned that order itself. The judgment of the Honorable Supreme Court. So what
we're concerned with you leaseholders, whatever.
Yes. So as far as their case is concerned, the Honorable Supreme Court has directed let the proceedings be concluded. In the meantime, you should not be evicted.
Okay. So you want to benefit same order.
Same order. That's all for the time being. That will not really affect them in any way.
Stop. As it is submitted that a collateral matter is pending consideration before the Honorable Supreme Court, wherein by order dated.
That's 16 to 26.
26 has been directed as follows. You quote this order. Mr. S. Sen appearing for the petitioners praised that they may be given the same benefit of the order of the Supreme Court. Next by Mr. S. P. Manta.
Because
reservations.
The demand they are to complete that as per the division bench order. No state to that.
Do have reservations in view of the fact that proceedings have since concluded.
Yes.
And they are to
deposit
petitioners to make the requisite deposits as per the demand. However, in view of the pendency of the connected matter, collateral matter before the Honorable Supreme Court, the benefit of the order dated
16 to 26 to 2026
we shall also apply to the petitioner.
Lordship.
Yes.
But there may not be a stay to the state.
No, that has not been stayed by the Supreme Court as well.
Only eviction.
Only the eviction. We
treat only the eviction. Correct.
No eviction.
There's similar order for the second item as well. The both two parties. But some time may be given.
6 weeks. Yes.
Lordship. Very grateful.
Apply.
22.
May please, Your Lordship. Yeah, Lordship, we have sent a second service copy to them, to the respondent, to the MECL. So we are in this case. You are.
Where's MSR Colony? Caller. You have to ensure that Sun Council is present. Where is she?
We have safe copy to the MECL.
Today you should have made your own personal contact with who's appearing. If you want the case to proceed. Yes, who's appearing in MECL?
I spoke to.
Yes, MSR Colony. You accept notice. Why? They have already served notice to the office. No one's appeared.
We have some copy to them because we have approached. We have approached the council. She said that I don't know.
We were not given the authority to receive the copies directly, my lord.
So you can't have this kind of arrangement. Since the last one litigation is MECL, it is they have to have standing counsel.
I can understand, my lord.
Judicial orders.
I understand, my lord. It's quite difficult for the councils also.
Then who will serve? You can blow hot and cold.
My lord.
The same thing we have.
No, yes.
Run from pillar to
as
post.
MSR Colony, it has been a regular, has been regularly conducting matters for the respondent. Yes. This court noting this fact. This court noting this fact directs that she apprise the respondents about the existence of this case and to enable her appearance on next date. Yes, what do you want?
Your Lordship, we have filed also the miscase
that would be difficult for me to...
releasing the petitioner withheld salary, and at the same time...
Another thing they will listed after 1-2 weeks. Yes. You appear next day. Copy of the order be given to the MS Alcohol. They can't have blue or cold. Or if you have to pass judicial orders, otherwise you can't have be like this. And even panel advocates processing the file here and there, when a matter comes up, they're not here. That also we will put some sort of a stop on it. Otherwise, you have and to assign counsels appearing in one matter, though they're not senior. That means that other counsel should be ready with the matter.
Yes, my lord.
What's happening is we've seen that actually only seniors allowed a junior. I've seen 2 or 3 government advocates appearing in a single matter.
My lord.
So if they're taking that shared responsibility, then they have the shared accountability also.
True, my lord.
Yes.
Supplementary 1, item number 1.
Yes.
Yes, Your Lordship. This is the second time the respondent KHDC
This is from where?
This is from Urksa Wapatao, Your Lordship, village.
So what happened? Nothing's happened.
My lord, after my lord, when the investigation was done, we could see that the money was transferred to one account, that is Subham. Now we are seeking the details from the NPCI, my lord, as regard to the bank and bank.
Who's the NPCI? Yes. Can't trace BJ Barik.
My lord, we have sent notice, my lord, to be served.
He would do the money.
Yes, and then money was ultimate beneficiary was this person, my lord. Subham. All the money is transferred to this account.
Who's the Subham? He's not arrested.
We are getting the details, my lord. We have already sought for requisition. All the details.
And Mr. Marpan?
Yes, Lordship.
From your side,
we have no say on this one because this is beyond our scope of having all this. It's all to the police and the concerned respondent.
Yes, this report has been filed today, indicating the fact that investigation is still continuing. Stop. Mr. Ensinkon submits from the report. It is seen that all the payment ultimately landed up in the account of one Shubham, SBHM, and that further action against this person is awaited. Yes. This is the matter. The status report dated 27 March taken on record just after 2 weeks for the orders. Yes.
Yes.
28.
Lordship, item 28 was mentioned in the morning.
It was mentioned. Yes. I mentioned the name.
Lagan Prasad.
I remember also mentioned.
36.
Maid, please, Your is Tanushka Chakravarti.
Yes.
Yes, madam.
It just gives good 5 minutes, huh? Five minutes.
Yes, madam.
My Lordship, I have already prepared written argument. Can I supply?
You already prepared an argument?
Yes, my Lordship.
Why argue?
I will give the verbal submission also, my Lordship. My Lordship.
Yeah.
My Lordship, the petitioner is belongs to the general category, my Lordship. After her 12th standard board examination, she has appeared in NEET examination for admission in MBBS course for the academic year 2025-26, my Lordship. For appearing in NEET examination, my Lordship, she has filed one application form, NEET application form. In the NEET application form, there are some columns are there, my Lordship. First is name, date of birth, category, eligibility, and fees, my Lordship. My Lordship, in this regard, I am to submit the entire NEET eligibility test. My Lordship, can you see the page number 6, my Lordship? Page number 6, my Lordship. Where it is in respect of payment of examination fees, my Lordship, the general category has to pay 1700, my Lordship, and ST candidate has to pay 1000 rupees, my Lordship. The general ST candidate, they paid 1000 rupees only after taking the benefit of the reservation policy, my Lordship. This is the one important aspect in this, my Lordship. So there is a specifically birds, my Lordship, adjustment of reserved category to unreserved category. If there is specific birds are there, they cannot migrate, my Lordship. Second, my Lordship, there's a information bulletin counseling scheme for MCC, my Lordship. My Lordship, can you see the page number, chapter 31, page number 47, my Lordship.
Page 37?
47, my Lordship. Those who are qualified in the NEET examination, they are supposed to enroll their name or for registering their name. This is the main, my Lordship. MCC counseling means it is a medical counseling committee.
Application form and fee of counseling.
Yes, my Lord. This is the main thing. After completion of the NEET examination, they have to register their name in the MCC counseling committee to get the seat, my Lord, allotted seat. So in this regard, my Lordship, page number 47. Here also, my Lordship, regarding the fee structure, my Lordship, they have already mentioned in the fee structure. Question number 2, my Lordship, what are the various fees to be paid in time of registration, my Lordship? If it is a deemed university, my Lordship, they have to pay 5000 non-refundable registration fee and refundable fee 2 lakhs, my Lordship. This is the mandatory. If anybody applied for MCC counseling committee, they have to pay this much of amount. And if it is, my Lordship, all India quota basis, my Lordship, non-refundable registration fees are 1000 rupees for the unreserved category, and candidates for ST category have to pay 500, my Lordship. And refundable security deposit for the unreserved category is 10,000, and
for general 2 lakhs.
No, it is deemed an university, my Lordship. And if it is all India quota basis, my Lordship, the non-refundable registration fees is 1000, and for ST candidate it is only 500, my Lordship. And refundable, if it is refundable, my Lordship, security amount, then it is 10,000 for the unreserved category, and for ST candidate it is 5,000. That is also performer defendant number 5. After taking the benefit of reservation policy, my Lordship, she has paid only 5,500. So that is, she has already availed the benefit of reservation policy, my Lordship. So she cannot be.
So in case that once you paid those fees, you can't migrate to another.
No, my Lordship. They have already appealed the opportunity, my Lordship. It is a rulings are there, my Lordship. High Court rulings are there, my Supreme Court rulings are there, my Lordship. So they she cannot migrate, my Lordship. So, my Lordship, in this regard, I have to submit 2 citations from Supreme Court, my Lordship.
What does it say?
Please give the citation. The citation.
I have already mentioned in my written argument. I have already given.
Written note. All right.
So, my lordship, allow me to read the.
Para?
Yes, my lord, allow me to read. This is the Union of India versus G. Kiran and others, my lordship. Para 3, my lordship. The dispute in the present appeal is regarding the claim of a reserved category candidate, that is respondent number 1, who availed relaxation in the preliminary exemption but was placed higher in merit than the unreserved candidate, that is respondent number 3, in the final merit list based on total marks awarded in the main examination and personally is to be treated as a general merit candidate for the purpose of cadre allegation against a general insider vacancy for the state of Karnataka in the forest service. This is the main. Then Malashi paragraph number 6, page number 4, Malashi.
What relaxation was appealed?
Malashi, in this case, they have already taken the cut-off mark, Malashi. They have taken the cut-off mark. General candidate, allow me to read, Malashi, paragraph number 6. Respondent number 1, page number 4, my lordship.
Yes.
Paragraph number 6. Respondent number 1 belongs to ST category and respondent number 3 belongs to the general category. Both appear for preliminary examination in the year 2000 as per examination rule 2015. The selection process for IPS involving 2 tiers, the civil service examination for the purpose of screening and then the forest service, my lordship. It is disputed that the preliminary examination, the cutoff to qualify by general category candidates was 267 and the cutoff to qualify SC category candidate was 233. Respondent number 1 secured 247.18 marks, which was below the cutoff to qualify as general category candidate, however declared qualified for the main examination. Appealing the relaxed cutoff applicable to SC candidates, simultaneously respondent number 3 secured 270.68 marks in the preliminary examination and qualified for the main examination, as the said score was above the cutoff for general category membership. Then my lordship, kindly turn the page number 10, my lordship, paragraph number 15.
Yes.
It is urged once a candidate performs on merit, surpasses the general standard and qualifies the main examination, scoring a higher rank than the respondent number 3, that is general category candidate in the final list, the grant of initial relaxation in the preliminary examination fades into insignificance. It is said that denial of the general insider in vacancy to a more meritorious candidate on the pretext of relaxation avail in the preliminary examination, which does not even more form the basis of final merit list, violates the principle of meritocracy and substantive equality as enshrined under Article 14 and 16 of the Indian Constitution. So, if it is anybody takes the relaxation, my lordship, or benefit of the reservation policy, they cannot.
No, but this is in regard to marks.
Yeah, there is.
Fine.
Yeah.
The other one is regard to fees only. Yes.
All are my lordship. All are my lordship. Then paragraph number, my lordship, 22, page number 16.
Yes.
In the above context, the word any in relatable to the relaxation or concession either in eligibility or any selection criteria, it further qualifies that such relaxation concession can be availed at any stage of examination, having relevance to the rule 1, which indicates that all candidates would be required to qualify the preliminary examination in order to appear in the main examination. Therefore, the proviso throw light by focusing on the issue of relaxation and concession in eligibility or selection criteria at any stage of the examination. At this stage, the point no pondered upon as this candidate obtains such relaxation or concession in eligibility or selection criteria. So, fees also comes in this one category, my lordship, eligibility criteria. What would be its effect in the matter of relocation, especially in the facts and circumstances of the case? So, my lordship, another Page number 30, my lordship. Page number 30, paragraph number 33, my lordship. The very recently in Sajib Roy, this court had occasion to deal with similar factual matrix as observed hereunder, my lordship. On an analysis of the aforesaid cases, we summarize as follows: whether a reserve candidate who has availed relaxation in fees, relaxation in upper age limit to participate in the open competition with general candidate may be recruited against unreserved seats would depend on the facts of each case. That is to say, in the event there is no embargo in the recruitment rules, employment or notification, such reserve candidate who have scored higher than the last selected unreserved candidate shall be entitled to migrate and be recruited against unreserved candidate. However, my lordship, this is the embargo, my lordship. However, if the embargo is imposed under the relevant recruitment rules, such reserve candidate shall not be permitted, my lordship, shall not be permitted migrate to general category. But Government of Meghalaya has not issued any circular in this regard that if any reserve candidate taken the benefits of the reservation policy, they can migrate from reserve candidate to unreserved category, my lordship. There is no such circular issued by the Government of Meghalaya, my lordship. So, conclusion, my lordship, paragraph number, page number 36, paragraph number 39. In view of the foregoing, we hold that Tribunal and the High Court were not correct in interpreting the relevant provision of Exam Rules 2013, paragraph 9 of the policy, and committed mistakes in granting the relief to respondent number 1. We hold that respondent number having availed the benefit of relaxed standard in the preliminary examination cannot be treated as candidate selected on general standard. So consequently, he is not entitled to be allocated against the general insider vacancy in the Karnataka cadre in place of respondent number 3. Accordingly, appeal is allowed. The input final judgment such and such passed by the High Court Karnataka in Bengaluru, writ petition such and such are hereby set aside and notification dated such and such for insofar allocating the Karnataka cadre to respondent number 3 and Tamil Nadu cadre respondent 3 is upheld as correct in eyes of law and without any allegation. So here it is also managed. They have clearly stated that if it is any reserve candidate, they have taken the benefits of the reservation policy, such as kind of fees in respect, concession of fees, relaxation on age, cut-off learning mark, they are not entitled to migrate from reserve category to the unreserved category. This is one citation, my lordship. There is another citation is there, my lordship. This is Sajib Roy. Shall I read, my lordship?
Yes, what paragraph? What paragraph?
Paragraph number 2, my lordship. Appellant have assailed common judge improved judgment and order dated 12/10 and order dated such and such whereby respondent lead petitioner who had applied as reserve candidate in OBC category after having availed age relaxation for the post of constable were directed to be considered for recruitment under the reserve category. Then paragraph number 22, page number 3 of 22, my lordship. Paragraph number 4. Paragraph number 4, page number 3, my lordship.
Yes.
All the respondent lead petitioner availed of such age relaxation for participating in the recruitment process. However, they were declared unsuccessful as they had scored marks lower than the last selected candidate in the OBC category for various departments. But their marks were higher than the last selected candidate in the unreserved category for those departments, claiming that they ought to be permitted to migrate the unreserved category. The respondent lead petitioner appeared in the High Court. Union of India opposed the prayer on the ground that respondent lead petitioner had applied in the OBC category after availing age relaxation, my lordship, and under such circumstances cannot be considered eligible for appointment in the unreserved category. Here it is, previous judgment was for lowering cut of marks, my lordship. This is for age, they have taken the benefit of the age relaxation, my lordship. Then, my lordship, last paragraph, my lordship, 21 of 22 page, paragraph number 32. Paragraph number 32.
Yes.
On the analysis of the aforesaid cases, we summarize as follows. Whether a reserved candidate who has availed relaxation in fees, upper age limit to participate in the open category, open competition with general candidates.
Yes, quoted in other judgment.
Yes, my lordship.
Yes.
This is Sajib Roy, my lordship. This
Next. What other arguments? That's all.
Yes, my lordship. My lordship, then my lordship. My lordship, Annexure 3, page number 21 of the main petition, my lordship. Annexure 3, page number 21, my lordship. Page number 21, Annexure 3, my lordship.
Yes.
The Government of Meghalaya, my lordship, on 8 September 2025 issued one addendum.
Yes.
Allow me to read, my lordship, addendum. The Government of Meghalaya is pleased to notify the standard operating procedure for seat allocation for the MBBS course for the academic year 2025-26. The SOB prescribed the procedure, timelines and responsibilities for the transparent merit basis and legally complaint admission for candidates to the 93 first year MBBS seat allocated to the state of Meghalaya from the following sources. So, if my lordship, you kindly turn the page and see the subclause 6, my lordship.
Yes.
The seat reservation breakdown, my lordship. If there is a out of 93 seats, my lordship, for Khasi Jantia category, they are 40% seats are reserved, Garo 40% and unreserved 15% and SC ST for 50%. My lordship, if it is out of 93 seats, 50% seats are exactly 14 seats for the general category, my lordship. General and I have selected exactly at serial number 14, my lordship. This Annexure 4, page number 28, my lordship.
28.
Yes, my lordship. I have exactly selected at serial number 14, Tanushka Chakraborty, my lordship. Page number 28, Annexure 4, my lordship.
Yes, okay.
I have already selected by the MCC Council after following the standard procedure of the operating system, and Government of Meghalaya was pleased to allot me a seat, my lordship. Just after that, my lordship, there is some NGO, they started agitation, my lordship, and on the pressure of the NGO, my lordship, the Government of Meghalaya changed their opinion and they have issued one more circular on this is circular annexure number 4 and page number 36, my lordship. Annexure page number 36, my lordship.
36 is annexure 6.
Annexure 6, my lordship. So where they have placed my name, my lordship, waiting list 13, my lordship. Once they have, after following the MCC guidelines, NEET examination rules.
Now who has replaced you? Diya Ghosh.
I have this is Record Ronkentry, my lordship. This is she is the performer defendant number 5, my lordship. So Government of Meghalaya, my lordship, illegally taken away my allotted seat and given it to the one respondent number 5 without following the proper procedure manner. Whatever they have already, I have already selected in this at the first notification, my lordship. Suddenly on the basis of the agitation by the government of some NGOs, my lordship, the government of Meghalaya, they are under pressure and they have issued one more notification, my lordship, on 7th October 2025, and they have placed in my place, they have selected recall not only one reserve candidate, and my seat I have placed in betting list number 13, my lordship. So my lordship, this is a totally illegality done by the government of Meghalaya, where I have already allotted seat, and without providing to me that seat, my lordship, they have given it to the somebody else, my lordship. This is totally illegal, my lordship.
Yes.
So my prayer is, my lordship, as I have already selected by the government of Meghalaya, and the Supreme Court citations are there, if anybody takes the benefit of the reservation policy, especially reserve candidate, they are not entitled to migrate from reserve category to the unreserved category, my lordship.
Yes.
My lordship, in my written submission, my lordship, page number 3, written submission, written argument, my lordship, I have already mentioned.
Yes.
Page number 3. Here are infirmities of the rules that have occurred in this case in hand and pointed below, my lordship.
Okay.
Page number 3, my lordship. Written argument, my lordship.
Last paragraph.
Yes, my lordship. Last paragraph. Bottom of the page, my lordship. Impact of concession. If a reserve candidate avails a fee concession or use relaxed standard, that is lower court.
Now one thing, you had been selected, that you go for counselling. Was over.
Yes, my lordship. I have already given my name is already mentioned in the notification, my lordship. 37/2025 at serial number page number 28, my lordship.
Well, that is seen, no, but you already gone to the college, finished counselling here.
Yes, yes. Then they have taken away my seat, my lordship.
Okay.
So it is totally illegal, my lordship.
Yes, Mr. Advocate General.
Lord, before I take your lordship to the legal arguments, my lord, first your lordship will kindly see the case of the petitioner in paragraph 2, my lord, of the writ petition. Whatever is argued, it is not there in the pleading, my lord, but I'll meet that argument also, my lord. Paragraph 2, if your lordship will kindly have page 5.
Yes.
The government of Meghalaya, paragraph 2, my lord, in its health services, medical education, research, Meghalaya, past institute has issued an advertisement for admission for first year MBBS in Shillong Medical College, and mentioning all state quota reservation backup, and clearly mentioned 37 seats for reserve, Khasi and Jantia, 37 for Garo, and 14 seats are reserved for general category. So it is wrong, my lord, to say that 14 seats are reserved for general category. There is no reservation for general category. These are unreserved seats. So entire premise of the petitioner is based on the fact that 14 seats are reserved for general category. There is no reservation for general category. And whatever is stated in the, whatever is argued today, my lord, there is not a single line in the entire pleading. But be as it may, my lord, on merit also, if your lordship will kindly see 2 documents only, and then I will take your lordship to the law on this aspect. My lord, kindly have page 28.
Yes.
Annexure 4, my lord.
Yes.
Now, if your lordship will find, this is 30th September 2025, and the petitioner's name is at serial number 14, unreserved. Yes. And kindly see the heading of this category is open category. Lordship has the top of the table left side, open category. And just kindly note down the number of the petitioner, 442, my lord. C is code 442.
Yes.
C is code 442, and kindly come to the impugn notification at page 36, my lord.
Yes.
And at the top of the table left side, my lord, it's an unreserved category. Your lordship may kindly note that unreserved category. And kindly see the marks of serial number 13, Record Noncre, 475.
Yes.
So she was having higher marks than the petitioner. Petitioner was having 442, my lord, and the candidate was having, my lord, for the reserve category, open category, she was having 475. Now, my lord, Divya Ghosh is also having higher marks. Then, my lord, there are candidates, they are unreserved candidates, Nikki, Sheila, Omar, Farooq, Rampi, Toi, Satyan Paul, Brian Linon. All these candidates are having higher marks than Tanushka Chakravarti at serial number 13, my lord. So they are all open category candidates. Open
Twice.
category candidates.
Now she scored 442, 12 versus 442, allotted under Kane. Okay. Only 14 seats unreserved. Right.
Under 14 seats only, my lord. So we have arranged the candidates in order of merit, my lord. And in the merit list, she is the lowest in the unreserved category, my lord. Above her, so many general candidates are also there. So she has no right to claim admission against unreserved candidate because she is having lowest mark in the entire lot, my lord. And she is not the mistake which was occurred, my lord, at page 28, and it was discovered that she is, if you also will see, she is having
yes.
So therefore the law on this point is well settled, my lord, that a unreserved candidate having higher marks is entitled to be treated as unreserved, my lord. The law is settled on this issue, my lord. Kindly have one judgment, my lord, of this judgment, my lord, is recent judgment 2024 SCC online, paragraph 10 to 16, my lord.
Paragraph?
This 2024 paragraph 10 to 16, my lord.
This is the judgment of Justice Gawai.
This is the judgment of Justice Gawai, my lord. Justice Gawai sitting with Justice K.V. Viswanathan.
Yes. You already gave copy last time.
Yes, last time I have handed over copy, my lord. By now, paragraph 10, your lordship, by now, it is well settled principle of law that a candidate belonging to any of the vertical reservation categories who on the basis of his own merit is entitled to be selected in the open or general category. Lordship may kindly mark this, who on the basis of his own merit is entitled to be selected in the open or general category will be selected against general category, and his selection would not be counted against quota reserved for such vertical reservation category.
Yes.
So the judgments are cited, and my lord, in this case, my lord, even Indra Sahni is also clear, my lord, which is referred in paragraph. The Indra Sahni is in the other judgment, Saurav Yadav, my lord. Saurav Yadav, the lordship has the judgment of Saurav Yadav, paragraph 22. Saurav Yadav, my colleague is having. Para, your lordship, in Saurav Yadav, your lordship, para 22.
Yes. Yes.
It says, my lord, para 9 of Rajesh Kumar Daria versus Rajasthan Public Submission referred to the well-established principle that a candidate belonging to any of the vertical reservation category on the basis of his own merit is entitled to be selected in the open and general category, and such eventuality his selection is not to be counted against quota reserved for such vertical reservation. We may refer to the sake of clarity reproduce the following extract, my lord. The judgments are, my lord, I am not repeating, my lord. Kindly see next page, my lord, which is the Constitution Bench judgment at Indra Sahni, my lord. On next page, my lord. Indra Sahni versus Union of India, commonly known as Mandal case, this court held thus. In this connection, it is well to remember that reservation under Article 16(4) do not operate like communal reservation. It may well happen that some members belonging to any scheduled caste get selected in the open competition field on the basis of their own merit. They will not be counted against quota reserved for scheduled caste. They will be treated as open competition candidates. R.K. Sabawal, the Constitution bench considered the question of appointment, and promotion, roster point. That is not the issue, but the principle is well settled that if a candidate is belonging to any of the reserve category, is having higher marks, that candidate has to be treated against the open category. There is no communal reservation. Now, my lord, two judgments have been cited by learned colleague, my lord. Those are all distinguishable. And kindly see the first judgment, my lord, latest one. This is Justice J.K. Maheshwari's judgment, 2026, SCC Online, SC 22.
This is
Yes,
just give me the page 26.
2026 SCC Online, SC, page 22.
Okay.
This was the judgment cited by my learned colleague, my lord, and if you also will see I will read what was their facts of the case, and if you also will see this paragraph 3 of the 2026 judgment, my lord. The dispute in the present appeal is regarding the claim of a reserve category candidate respondent who availed relaxation in the preliminary examination but was placed in higher merit than the unreserved candidate in the final merit list based on total marks awarded in personality to be treated as general merit candidate for the purpose of category allocation. So case is, my lord, that at the basic threshold, at the reserve category candidates avail the reservation for getting into the bracket, getting into the entire process. Here, my lord, in the present case, what has been cited that the candidate has given the fees of a reserve candidate, and therefore the private respondent has availed the benefit of reservation policy, my lord. In my humble submission, it would amount to stretching the entire judgment too far, my lord, because when I apply as a reserve candidate, my lord, I have to fill if I'm availing the age relaxation,
What happened?
This judgment will apply here. So far as this judgment is concerned, my lord, this judgment only says that if you have availed some benefit which give you entry into or permits you to get counted against the open category. I have, so far as private respondent is concerned, my lord, private respondent has only paid fees for reserve category, and your lordship knows when the application is made by me, I do not have choice to say that I will pay the fee of general category. My merit will be decided only after I appear in the examination, I score higher marks. Certainly, yes, if I appear in the examination, my lord, and then thereafter I take advantage of, or I take the benefit of, not advantage, benefit of some reservation policy or some relaxation in merit list, then certainly I cannot be treated as open category. This is therefore facts are completely distinguishable, my lord. Here there is no such benefit, and if you also will see one more paragraph which has been referred to, paragraph 22, my lord, of the judgment of this 2026 SCC Online SC 20 judgment, 22, my lord. This is the fulcrum or basis of the judgment, my lord. Therefore, merely because I have paid, the private candidate has paid the lower fees, will not denude or exclude the candidate, my lord. Paragraph 22, my lord. In the above context, the word any is relatable to relaxation or concession either in eligibility or in selection criteria. Your lordship may mark, if I take the advantage of eligibility or selection criteria, my lord. Here, private respondent has not taken any benefit for eligibility or selection criteria.
Yes.
the parameter or the real test is, my lord, whether a candidate has taken the concession or relaxation either in eligibility or in selection criteria, my lord. If the candidate has not taken any concession or relaxation in eligibility or selection criteria, then the candidate is having higher marks than the open category candidate. That candidate has to be treated as open category, my lord. It further qualifies that such relaxation concession can be availed at any stage of examination, because it was a preliminary having relevance to Rule 1, which indicates that all candidates would be required to qualify preliminary examination in order to appear in examination. Therefore, the proviso throw light by focusing on the issue of relaxation concession in eligibility or selection criteria at any stage. At this stage, the point to ponder upon if the candidate obtains such relaxation concession in eligibility, or what would be the effect in the matter of catalog. So this case is completely distinguishable. It is not applicable, Miller, and the private respondent has not taken any concession or relaxation in eligibility or selection criteria. Now coming back to my lord, second judgment, my lord. Paragraph 3 of the second judgment, 2025 SSC Online SC 1943.
Well, give me the citation again, 2025?
Yes, sorry, 2025 SSC Online SC 1943.
1943.
Yes, ma'am, 1943.
My lordship, I have already supplied my
You've
lordship.
given the
Same only, my
the
lordship.
same one, no. That's,
Same.
I'm taking from the.
No,
This is you've
same
given
only,
a
my
copy.
lordship.
No, I know you've given a copy of the judgment,
Yes.
but it's been reported in SC online. I'm taking the citation.
Because in the judgment,
This is neutral citation.
who is going to author will refer the citation.
Yeah, because in the judgment, I have to refer a citation.
Much.
That is. Paragraph 2, my lord, of the facts of the case.
Yes.
Appellants have assailed common impugned judgment, an order dated 12/10/2018, an order dated 26/2/2019, whereby respondent petition who had applied as reserve category OBC after having availed age relaxation for the post of candidate were directed to be considered for recruitment under unreserved category. So the fact, my lord, is that once again concession was availed, or in respect of eligibility was availed in respect of age relaxation.
Yes.
It's not the case of petitioner here, in my lord, that respondent number 5 has availed any concession or benefit in either in eligibility or in selection criteria. So therefore, my lord, this judgment is also completely not applicable. One more paragraph was read before to your lordship, paragraph 32, my lord. On an analysis of the aforementioned cases, we summarize as follows: whether a reserve candidate who has availed relaxation in fees and upper age limit to participate in open competition with general candidate may be recruited against unreserved would depend on facts of each case. Kindly mark facts of each case. It's not there is no universal law which is being laid down by the Honorable Supreme Court. That is to say, in the event there is no embargo in the recruitment rules or employment notification, such reserve candidate who have scored higher than the last selected unreserved candidate shall be entitled to migrate and be recruited against unreserved candidate. So if there is no embargo, my lord, my learned friend failed to show any embargo in my SOP also, that there is no embargo. However, if an embargo is imposed under the relevant recruitment rules, such reserve candidates shall not be permitted to migrate to general open. So therefore, my lord, in this case also, paragraph 32 also, my lord, it goes in my favor, my lord. These two judgments are in my favor, my lord. These two judgments clearly lay down that if the eligibility or selection criteria, the benefit has been availed by a candidate or a reserve category candidate, and he or she scores higher than that candidate has to be treated as open category, my lord. I have referred to 2-3 judgments, my lord. Saurav Yadav is also on that point, my lord. That is 3 judges bench judgment also, which I have shown placed, my lord. That is 2021 4 SEC 542, my lord. 2024, that paragraph 22 is also clear, my lord. Then I have referred to, my lord, 2024 SCC online 2058, my lord, on this proposition. That is Ram Naresh alias Justice Gawai judgment, my lord. Before that also, my lord, there is a judgment of the Supreme Court, Jitendra Kumar Singh versus State of Uttar Pradesh, my lord, 2010, 3 SCC, page 119, my lord. 2010, 3 SCC, page 119, my lord, paragraph 51. Your Lordship has paragraph 51 of this judgment, my lord.
Yes.
Paragraph 51, my lord, and it refers to the argument, somewhat similar argument. We are paragraph 51. Further of the considered opinion that reliance placed by Mr. Rao and Dr. Dhawan on KL Narasimhan is misplaced. The learned senior counsel had relied on the following observations. 5. Only one who does get admission or appointment by virtue of relaxation of eligibility criteria should be treated as reserve candidate. The aforesaid line cannot be read divorced from the entire paragraph, which is as under, and it was decided that no relaxation in respect of qualification or experience would be recommended by a scrutiny committee for any of the applicants, including candidates belonging to Dalit and tribes. In furtherance thereof, the faculty post would be reserved without mentioning the specialty. If Dalit and tribe candidates were available and found suitable, they would be treated as reserve candidate. If no Dalit or tribe candidate was found available, the post will be filled by general candidate. Otherwise, the reserve post would be carried forward to next year advertisement. Now, my lord, these 4 lines, it is settled law that if Dalit or tribe candidates get selected for admission to a course or appointment to a post on the basis of merit as general candidate, he should not be treated as reserve candidate. Only those who get the admission or appointment by virtue of relaxation of eligibility criteria should be treated as reserve candidate. So this issue is also very clear, my lord. The private respondent in the instant case has not got any concession or relaxation in the eligibility or selection criteria. Therefore, these 2 judgments are in my support, the recent judgments also, and series of judgments are also in support of the case of the state. By selecting meritorious candidate, my lord, we have applied the law and we have upheld the law. That is all I have to say.
Yes, Supreme Private Respondent. No private respondent appearing?
No, my lordship.
Yes. Any reply? Yes.
My lordship, can you, my lordship, can you see the information bulletin of counseling scheme? And this is MCC Counseling Committee, my lordship.
Is it a petition?
No, it is a book I have already supplied, my lordship.
MCC?
Can you see the page number?
This is the one?
Yes, my lordship.
Page?
Page number, page number 3, paragraph number 8, my lordship.
Yes.
Candidates should ensure that all the information filled during the online submission of application registration form is correct and factual. Information provided by the candidates in online application registration form shall be treated as correct and self-certified, and MCC shall not entertain under any circumstances and request for change in the information provided by the candidates. Then paragraph number 9, my lordship, MCC does not change, edit, modify, alter any information that is such as name, date of birth, category, nationality, contact details entered by the candidates at the time of online submission of the application registration form for counseling under any circumstances, my lordship. So this is the MCC is a counseling scheme, my lordship. They have clearly stated in their book, my lordship, that MCC does not change, edit, modify, alter any information which was already provided by the candidate, my lordship. The data entered by the candidate at the time of registration, NTA, National Testing Agency portal, will be preloaded and will be used for counseling purposes. Candidate must note that Nata.
This all documents are not on record, not part
No,
of
my
the
lordship,
pleading.
this is the on the basis of NEET examination and MCC, they are allotted the
There is
MBBS.
nothing, no reference
It
in
is the main
report.
basic necessity, my lordship. This NEET examination application form and the MCC counseling committee, these are the basic
But only one
necessity.
thing you must understand is that these pleadings are not there in the petition. So with regard
But
to
my lordship, I have already, my
the
lord.
court has to, do an inquiry basing on these guidelines. They have to be on record, and they be given a chance also to rebut. That's the thing. We can't now make submissions outside the.
No, my lordship, I have already mentioned in my petition, my lordship.
But
These
where
are
have you annexed these guidelines?
guidelines I have not annexed, my
Where have
lordship.
you mentioned in the petition?
Let me check.
It's not there, my lord. In the petition also it is not there.
Let us
There is
show.
nothing.
Because my lordship, this is the when a candidate applied for the NEET examination, these
Where
are
in the
basic
petition you refer to these
NEET examination, my
guidelines,
lordship.
guidelines?
My lordship, paragraph number 1, my lordship. Copy of the National Eligibility Cum Entrance Test UGC scored card annexed and marked as Annexure 1. After applying the NEET examination application form, my lordship, she has eligible for MCC counseling for process, my lordship. Only after that, my lordship. So I have already mentioned in my application, my lordship.
No. What this court is saying, you mentioned it well and good, but pointing specifically to the parts of the guidelines that help you, that has not been pleaded in your petition, because these will be your grounds of challenge, correct?
Yes,
for deprivation of your seat, which was given and taken away. Now all those have to be in the proper form. Now you have said first point is that now though you have not said it, but then okay fine, this court will look into that also regarding eligibility and whether once you pay a fee for unreserved, whether you can migrate. That point is the first point. Now other points with regard to you can't change the data that or whatever information you have already submitted. Now that is there's no way that you say that once what has been done, counting has been done, then it is the end of the matter. That is not there also in the petition.
My lordship, if any candidates supposed to apply for any examination, they first of all they have to apply online application form. This a NEET examination is an online application form. After qualified NEET candidate, they are supposed to go or register their name on the MCC counseling committee. Then they are entitled to for MBBS seat, my lordship. So this is the basic necessity, my lordship.
Yes.
So without going through these two sets of application form, my lordship, no candidate is allowed to be sit for MBBS seat.
Okay.
So this is the basic necessity. This is a very first preliminary information, my lordship.
Have you heard judgment reserve?
Much obliged.
Grateful.
Please, Your Lordship. Your Lordship, I deeply apologize, Lordship, with regards to the matter that I have appeared in regarding the Sardar, Your Lordship. He is pleaded as a respondent, Your Lordship. It went completely out of my sight, Your Lordship.
In your eagerness to move answer motion.
Lordship.
Yes. Accused Sardar's party.
Yes, Lordship. Please respondent number 3, Lordship.
Very good. Yes.